Welcome to Law Sessions. I am Jennifer Housen. In this law session, for land law, we will be considering mortgages. Mortgages is one of the more easier topics to grasp, as opposed to, say, leasehold covenants or freehold covenants. But nevertheless, mortgages is not terribly difficult because most people will have some idea of what it is I'm talking about. So, without further ado, let's try and see how we will wade through the topic itself. Well, if we start off first of all with how do we get to this whole idea of mortgages? Well, when you consider the cost of buying property today, very few people, not unless you're extremely wealthy perhaps, very few people can afford to buy a house outright. So most people will have to seek help by borrowing the money to purchase their home or land, and this is commonly done by way of obtaining a loan or a mortgage from a bank or building a society, which is then secured against the land in case the borrower becomes unable to repay the monies. Now, before we start into the lecture itself, I really need to go through some definitions so that you understand what it is that you must understand the usage of the terms we will use as we go through. Now, what is a mortgage? A mortgage is a disposition of some interest in land or property as a security for the payment of a debt or the discharge of some other obligation for which it is given. The mortgage is the security and not the loan itself. Now, this is interesting because a lot of times people will say that the bank has given them a mortgage. Well, the bank has never given anyone a mortgage in its life, except maybe the people who they've borrowed from for their building. But the bank doesn't give you a mortgage. What you will find is that you actually give the bank a mortgage. What the bank gives you is the money. So, what a mortgage is the security for the money. The mortgagee, therefore, and as you know with law generally, when you have EE, so it's a person receiving the thing, and or is the person giving. So for example, when you look at covenantor is the person giving under the covenantee is the person receiving. So when you look at a mortgage, the mortgagee is the person who receives the security, which is of course the lender, the creditor, the bank. So that's why the bank is called the mortgagee, because he receives the mortgage, which is he receives the security over the property. The mortgagor is the person who gives the security. So the mortgagor is actually the homeowner. So the borrower or the debtor is of course the mortgagor. If you consider a definition for charge, when we talk about a charge over the property, we're talking about conferring rights in the land or the property on a charge for the lender as security as before. Now, some interesting terminologies here, but again, like I say, it is not very difficult to assimilate. Redemption and the equitable right to redeem. Well, these talk about the right of the mortgagor, the homeowner, to repay the loan and claim back the land or the property free from the encumbrance. Meaning, of course, the loan free from the encumbrance, exercisable after the date fixed for repayment has passed. So, the equity of redemption is basically the totality of the equitable rights of the mortgagor, including the right to redeem. It's the right to redeem its value and basically pay off your debt. So then, what is a mortgage? Let's start looking at what this lecture is about. Well, as I said, the concept is not entirely too difficult to grasp. The borrower borrows a sum of money from the lender and he agrees to pay these monies over a set period of time, in addition, of course, to interest. And he also then agrees to repay the amount outstanding, and so the borrower agrees to a number of terms and conditions, which of course are laid down by the lender. Because if I'm the bank and I'm lending you the money, in order to buy your house, then I want to make sure that certain things are in place and that certainly you have conditions which you have to submit to. Now, if the borrower cannot repay the money or he breaches any of the terms and conditions agreed with the lender, of course, may sell the property in question in order to recover what he is owed. Now, in the case of Santley and Wild, an 1899 case, a mortgage was defined by the courts as a conveyance of land as security for the payment of a debt or the discharge of some other obligation. Now, there are two classifications of mortgages which can be created. As with other interests in land law, a mortgage can be legal, it can be equitable. And we will certainly look at these later on when we consider the creation of a mortgage. Now again, I must remind you that regardless of what topic you are doing, you have to consider what is the right you're considering. Is it an easement? Is it a lease? Is it a mortgage? So the first thing is to consider the right. The next thing is to consider, is it legal or equitable? And of course, the last thing, is it registered or unregistered land? And if it is, how is it protected? So bearing that in mind, you can, of course, have a legal mortgage. Certainly, of course, can have an equitable mortgage. Now, from a commercial point of view, there are different types of mortgage that exist, but that's from a commercial point of view. I'm just flagging these up here for information purposes, but certainly you will see how, for example, they come out in the cases. When you consider an acquisition mortgage, this is where money is advanced and used for the initial purchase of the property. Now, the acquisition mortgage is interesting when you look, for example, at a topic we've already considered, which is in a context of co-ownership. The acquisition mortgage is where you're buying the property for the first time, and therefore you needed the monies in order to buy the property. So even if you had a down payment, you needed the monies in order to buy the property. This has to be contrasted with a repayment mortgage. But if you go back to co-ownership, you will see, for example, in Abinashal and Khan, where you have a co-owner in equity, as it relates to an acquisition mortgage, they are not able to have their interest override that of the mortgagees because the monies was used initially to purchase the property. Of course, it's a different story when you're looking at a situation where it is not an acquisition mortgage. So an acquisition mortgage can either be a repayment mortgage or an endowment mortgage. And repayment simply means that you pay back the interest with the principal. And endowment simply means that you pay back an interest only. Now, again, if you go back to a previous lecture where I'd raised the case of Tinsley and Milligan, where I talked about the lesbian couple who had sought to defraud the DSS, we see that maybe they wouldn't need to have defrauded the DSS had they gone probably for an endowment mortgage because, again, the DSS are quite happy to pay the interest-only portion, but certainly not the repayment. So besides an acquisition mortgage, of course, you have a non-acquisition mortgage. And this is where, for example, a house is used as security for borrowing after the house has been acquired. Then in principle, either of the types of mortgages I've mentioned can be used, which is, of course, the repayment or the endowment. Now, when you're looking at the creation of a legal mortgage of freehold or leasehold land before 1925, I want you to understand the historical aspect of it in order to be able to understand where we go from here, especially under the LRA. Historically, and prior to 1925, a conveyance of the fee simple to the mortgagee or an assignment of the residue of the terms of years to the mortgagee respectively, subject to a covenant entered into by the mortgagee for the reconveyance or reassignment of the fee simple or residue of the term to the mortgagor as appropriate. That's a bit of a mouthful. What does that mean in practice? So prior to 1925, how did you create a mortgage? Well, a mortgage was created by the mortgagor which is the borrower, charging the property to the lender. The property or the legal estate would be transferred to the lender. So it would transfer in its entirety. You will see how that differs nowadays. But what used to happen was, I go to the lender, I want to borrow some money in order to buy that property. The lender was the one who was the legal owner of the property. Nowadays, that's not the case. The homeowner is the legal owner and the bank has no more than a charge. So you would hand it over to the mortgagee as security for the loan. Therefore, if the borrower defaulted on the debt, as the lender was the legal owner of the property, they could sell it or let the property, rent it out, in order to recoup the debt and their expenses. If the borrower kept to the repayments and the terms and conditions of the loan under the agreement between the parties, then the legal estate would, of course, be reconveyed to the mortgagor when the repayments were made in full. So, the effect, of course, was that legal title was transferred to the mortgagee. The mortgagee could therefore enter into possession, and on non-payment of the debt, the mortgagee retained ownership of the land. And of course, when you look at the equity of redemption, equity began to interfere as they saw that this was unfair. Because given that, when you look at the situation, you're paying, but the legal owner, of course, is the bank. So equity looked at the unfairness of this and gave certain rights to the mortgagor, known as the equity of redemption. And these rights, of course, included any profit earned from the property during the mortgage by the mortgagee was to be handed over to the mortgagor. Also, the mortgagor was permitted by equity to repay the debt at any time after the contractual date for repayment had passed. Nowadays, in order to retain the land after the date for repayment had passed, the mortgagee had to apply to the Chancery Court for a decree of foreclosure. The court would consider the amount of the debt outstanding in relation to the value of the property and would either allow the mortgagee to retain the title to the land or would order that the property should be sold and the debt repaid to the mortgagee out of the proceeds of sale. That is pretty much what happened in that scenario prior to 1925. Well, what happened after 1925? Well, the system of mortgages was radically overhauled and is now governed by the Law of Property Act 1925, Section 85 to Section 87, with the implication of the Land Registration Act 2002. This is that the only form of mortgage or charge being capable of being registered against a registered legal estate by the land registry. Now, there are two different ways that a legal lease can now be created. I'm talking about a legal lease, but really what I'm looking at here is the new way that a mortgage can be created. Now, we see in the old way, or prior to 1925, the lender owned the property legally. Now, though, we see that the borrower owns it and that the mortgagee has a charge. We're going to break, and when we come back, we will start afresh as to looking at the current position since 1925.